Hi everyone, this is Attorney Luis Victoria from Miami, Florida, here in the United States of America. We are going to talk about the O-1 visa. The O-1 visa is a non-immigrant visa for individuals with extraordinary abilities or achievements. Don't move from there because this is a very important information. This is one of the most important visas that I can find for those people who have special skills, and maybe sometimes you don't know which visa to use to live here in the United States. Don't move from there because we are going to talk about the different elements, the eligibility criteria, and how to apply for this important visa. Thank you. Thank you so much for being here and being one of our subscribers. If you are not yet subscribed in our YouTube channel, we invite you to subscribe in our YouTube channel because you are going to be provided with excellent information, with content information, which is very useful, not only for you, but also for your family, for any friend that you may have, or for you, for you to be able to achieve your American dream. So we are going to talk about a non-immigrant visa today, the O-1 visa. This O-1 visa, as I told you before, is a visa which is very directed to those people who possess extraordinary abilities in the sports, in the science, arts, education, business, or athletics. So this specific visa is divided in O-1, A, O-1B, O-2, and O-3. Specifically, the O-1A is for those individuals with extraordinary abilities in the science, education, business, or athletics. So the O-1B visa is for individuals with extraordinary abilities in arts or with this type of extraordinary achievements in motion picture or television industry. On the other side, the O-2 visa is for individuals who will accompany the O-1 artist or athlete to assist them in the specific activity or event while they are here in the United States. On the other hand, the O-3 visa is for those individuals who are relatives, immediate relatives, specifically the spouses for the O-1 applicants, and also the children. It means younger than 21 years old of O-1 visas or O-2 visas holders. So as you can see, this visa, it is a very important visa. Maybe sometimes the person who has extraordinary abilities may change in the future for an EB-1 visa. The EB-1 visa is an immigrant visa, but you have to consult with your attorney in order for you to be able to know which skills you may use, or if you are able to use these skills for that type of change. So going forward with the general eligibility factors, it is very important that you must know that the O-1 visa applicant, you must demonstrate extraordinary abilities by sustaining national or international acclaim. This means that, for example, people who are in the science, education, business, or athletics, means that level of expertise indicates that you are one of the small percentage who have arisen to the very top of the field. So in other words, you have achievements in this specific field, sports, education, or businesses, and you are an extraordinary person. On the other hand, if you are in the field of arts, so your extraordinary abilities means distinction. Distinction in the arts means a high level of achievement in the field of the arts. So this evidence is comparable by a degree of skill and recognition, so that you are in that specific level, to the extent that you are a prominent person, a noble person, a leading person in that specific field of the arts, or a well-known in that field of arts. So on the other hand, if you're in the motion picture or television industry field. So to qualify for the O-1 visa, you must demonstrate extraordinary achievements like you obtain or you achieve, for example, a Grammy prize or an award which is internationally recognized. So that's very important. So on the other hand, so lastly, the O-2 visa holders, in order to apply for this visa, they must assist the O-1 holders with a critical skills and experience for the O-1 visa holder to be able to develop that skill here in the United States. So the application process. So the application process is very important to know that you must have a U.S. employer or a U.S. agent. So for these people, for the employer or agent to apply for you for a petition for a non-immigrant worker, so on your behalf. So once they apply on your behalf for this type of petition for the non-immigrant worker visa, which is the O-1 visa, along with the required evidence, so the person is going to say you have those skills, therefore you are going to be able to work here in the United States through that specific visa O-1. So your employer or agent should file the specific form at least 45 days before the date of employment. The person, this employer or agent, cannot file this specific application more than 100 days before your employment date. So also a very, very crucial aspect to keep in mind is that the petitioner must provide a written advisory opinion from a peer group, which means a labor organization, for example, or a person also who may provide that written advisory opinion can be a person with expertise in the beneficiary's area of ability. So it's an expert in that specific field in the science, arts, sports, athletics, also businesses or education. So when a consultation includes, for example, a watermark in that specific letter, so it has to be provided in originally. So in the original document. So it cannot be a copy. So you need to provide a contract between the petitioner and the beneficiary. So the petitioner must submit a copy of any written contract between you and the petitioner, or a summary of the terms of the oral agreement under which you will be employed. So also you must include the itineraries. The petitioner must provide an explanation of the nature of the events or activities that you are going to develop here in the United States at the beginning, so with the beginning and the ending dates for that type of events or activities. So the petitioner must provide evidence demonstrating, as I told you before, of your extraordinary abilities. So the record means the evidence that you are bringing to the case must include at least 3 different types of documentation. So this type of documentation is letters of recommendations, so other type of awards that you have achieved during your life as a expert. So, and this evidence must as a whole demonstrate that you meet the relevant standards for that type of classification. So another aspect to keep in mind is how long can you stay with this visa here in the United States. The initial period of stay is up to 3 years. So the USCIS will determine the time you need to accomplish the initial event or activity in increments up to 1 year. That's very important to know. So because you can have extensions later on. So in other words, to be able to obtain this O-1 visa, so you must provide that you are extraordinary, that you have those extraordinary abilities. This is an important option for those who don't know which visa you may use in order to live here in the United States. So if you have skills, so maybe you will be able to apply for that visa. Sometimes people with skills, they don't know about this type of visa. Thank you so much again for being here in our YouTube channel as our subscriber. So we invite you to continue experience this information. Thank you so much for being here.